If it may please this honorable court, the council is appearing on behalf of petitioners Sameera and Kiran Khanna, being represented by their mother, Mrs. Kajol Khanna, as next friend, appearing before the Honorable High Court of Aravali City. Council seeks permission to collectively refer to the bench as Your Honor. Much obliged, Your Honor. If Your Honor is well versed with the facts and jurisdiction of the case, much obliged, Your Honor. Issue 1. Issue 1 deals with validity and proof of the purported will. This issue will be dealt with in a twofold manner. Failure of animus attestandi. Secondly, the half-witness doctrine. So firstly, Your Honor, while the testator's signature is acknowledged, the law dictates that will is not a mere paper, it is a document that must satisfy judicial conscience. And the same has been upheld in the case of H. Venkatachala versus B.N. Iyengar versus B.N. Thimmajama. Under Section 63C of the Indiana Succession Act, it is not enough for a witness to merely sign the paper, but they must have the specific intent to witness the testator sign a testator signature. This principle is known as animus attestandi, which was established in the case of Girja Dutt Singh versus Gangotri Dutt Singh. The law also requires that there must be two witnesses. If Your Honors may refer to Annexure B of the Moot proposition, while the witness Shruti Malhotra deposes her own intention, she remains silent on the attestation of the second witness, Amit Mehta, which due to her absence during his attestation, thus rendering Section 3 in principle unfulfilled in the present case. Secondly, the half-witness doctrine. Under Section 68 of the Indiana Evidence Act, there is a concession that at least one witness is allowed to be produced to court to prove the an attested document as evidence for the court. But in this case, the rule established in the case of Janki Narayan Bhoyer versus Narayan Namdev Kadam states that a single witness, when produced to court, must be able to prove the entire process of execution, including the fact of the other person's attestation. The evidentiary gap is created through the fact that Shruti Malhotra is not able to attend the signature of Amit Mehta attestation. Thus, by failing to prove the second attestation, she becomes what law classifies as a half witness, rendering Section 68 of the Indiana Evidence Act unfulfilled. Thus, this will cannot be proven in a court of law. If Your Honors are satisfied with these submissions, much obliged, Your Honor. Issue 2 deals with allegations of forgery and its legal consequences. This will be dealt in a threefold manner, following a sequence of chain of suspicious circumstances, legal impossibility of a will, and Section 340 of the CRPC. First of all, a chain of suspicious circumstances. Your Honor, the Council would like to refer to a chain of suspicious circumstances that happen, which provide enough preponderance of evidence which is sufficient substance to prove forgery and fabrication. Firstly, under Annexure C of the Moot proposition, there is an unexplained transfer of 15 crore rupees to Prasha Sehgal just before the testator's death. Under Para 6 of the Moot proposition, there is an attempt of selective submission of the beneficial interest forms to the Ministry of Corporate Affairs in order to claim the assets that are housed under the trust. And lastly, there is an exclusion of natural heirs of the deceased, that is Sameera, Kiran and Mrs. Renu Khanna, although they had good relations with the testators before his death as well. All of these circumstances point to a fraudulent design of Prisha Khanna. Secondly, there is a legal impossibility of the will. If Your Honor may refer to Para 3 and 4 of the Moot proposition, after the death of Sanjeev Khanna, Prisha claimed initially that all his assets were housed under a SK family trust. And suddenly, on 30th July 2025, a purported will was brought into the picture along with Shruti Malhotra, which itself is a suspicious circumstance. Now, under the Indiana Trusts Act, once Sanjeev Khanna has transferred his assets to a trust, those assets no longer belong to him as personal assets, and thus he cannot bestow those assets upon anyone else through a will. Thus, this creates a legal impossibility of a will, and a seasoned industrialist like Sanjeev Khanna would not attempt to override his own attempts to make a trust itself. Invoking Section 340 of the CRPC is essential in this matter. The fact that the will attempts to override a prior trust is not a mere suspicion, Your Honor. It's evidence of forgery under Section 467 of the IPC, which talks about the forgery of wills, valuable security, or authority to adopt a son. Thus, the court must invoke the authority under Section 340 of the CRPC to file a criminal complaint of forgery. If Your Honors are satisfied with the submissions under Issue 2, Council seeks permission to move to Issue 3. Much obliged, Your Honor. Lastly, issue 3 talks about seal covers, confidentiality, and NDAs. This issue will be dealt in a fourfold manner: transparency as a statutory mandate, violation of open justice, conflict with public policy, and finally, failure of the proportionality test. Firstly, under Section 276 of the Indiana Succession Act, the valuation of assets is not a private matter, it is a procedural requirement, especially in inheritance cases and probate petitions. Under the Court Fees Act of 1870, it is a jurisdictional necessity that determines the court's pecuniary authority. A sealed cover itself prevents the courts from verifying if the suit is even maintainable within its jurisdiction. Further, under Order 11 of the CPC, there is a discovery of right and inspection that is to the other party, that they can inspect the documents that are produced against them in the court. Lastly, Section 123 of the Evidence Act protects only state secrets and not personal matters like will, thus their demand for confidentiality fails. Secondly, violation of open justice. As held in Madhyanam Broadcasting Limited versus Union of India, sealed covers are an exception reserved for compelling state interest and not for public matters. As a private inheritance dispute, regardless of family stature and the high stake of the case, it does not qualify to be produced in a sealed cover. The asset list does not prove. Referring to para 14 of the Moot's proposition, limited confidentiality through a denial of media trial has already been provided to the respondents, and thus the demand of sealed cover becomes an irrational one, and the sealed covers of documents can be challenged, arguing violation of open justice. There is also a conflict of public policy. Forcing the council to sign NDAs creates a conflict of interest, restricting them from effectively advising their clients, which violates the principle of audi alteram partem, which means both sides have the right to be heard. Lastly, under Section 23, there is a violation of public policy. Section 23 talks about unlawful objects and considerations in contract. This NDAs itself they are also they are considered by the court as problematic, which consider them as against public policy. Lastly, the proportionality test that was instituted in the case Puttaswamy case requires for their demand fails the proportionality test, as even assuming legality of privacy or confidentiality claims, it is not reasonable, or it is not rational to ask for a blanket cover on the asset list, and the petitioners have a right to verify the asset list as well as the other documents that were produced in court. Second of all, it fails the necessity test, as it is not it is not a necessity to be produced in a sealed cover. A redaction of documents can be allowed, thus making it a less restrictive measure. And lastly, the balancing test, a right to verify and right to the right to verify and of the petitioners far outweigh the speculative demands of privacy and confidentiality, which are itself unconstitutional in the court of law. The Council 1 submits submissions under issue 1. Their demand itself for privacy and confidentiality are constitutionally disproportionate, and they should not be provided because they fail the test of necessity and balancing that were under the proportional.
Prisha has not provided the document. That's the reason.
Your Honor, Prisha has asked for confidentiality by asking for a signing of NDAs as well as filing the asset list under the seal cover. This itself is not a less restrictive measure to produce the documents in court. A redactive asset list can be produced in court. Thus, it fails the necessity test, and failing the overall proportionality test that was in the Puttaswamy judgment. Therefore, it being constitutionally disproportionate. The demand is disproportionate to what is actually required of the case. Thank you, Your Honor. Pardon, Your Honor? I'm so
Will
sorry.
deed is required registration.
In what way the document is required to be executed?
The document,
Will execution.
the will execution. The will is supposed to be executed under Section 63 of the Indiana Succession Act, read with Section 68 of the Indiana Evidence Act, which qualifies that there must be two witnesses. They must sign within the testator's presence, and they must see the testator sign.
Registration not required.
Sorry, Your Honor?
Registration of the whether the registration of the will is required or not.
Registration of the will is required, Your Honor.
So this will is registered.
The registration of will has not been provided in the moot court proposition, thus we cannot state the same.
You have not raised any objection in this regard.
Sorry?
You have not raised any objection in regarding of this registration of document.
Your Honor, as it was not actually written in the moot proposition, therefore we did not make any assumptions regarding that, thus no objections were raised. Thank you, Your Honor.
Greetings to the bench. If it may please this honorable court, this is the co-counsel appearing on behalf of the petitioners. Your honors, I'm going to start with issue 4, entitlement to interim reliefs. Your honor, under order 39 rule 1 and 2 of the CPC, this court is empowered to grant temporary injunctions when property is in danger of being alienated or wasted. As held in Dalpat Kumar versus Prahlad Singh, the plaintiffs must demonstrate a prima facie case, a balance of convenience and irreparable injury. Furthermore, the case of Maharwal Kevaji Trust versus Baldev Das mandates that status quo should generally be maintained.
Which issue you are dealing?
Issue number 4, Your Honor.
Issue number 4.
Yes, Your Honor.
Continue.
Yes. Mandates that status quo should generally be maintained to prevent third-party interventions. It is a prima facie case because the will is shrouded in suspicious circumstances. It excludes the deceased mother and minor children despite a healthy relationship and recent family vacations. The sudden update of MCA beneficiary forms in August 2025 favoring only the respondent raises a substantial question of fraud that requires trial. Secondly, it has element of balance of convenience. If the respondent dissipates the rupees 30,000 crore estate or transfers promoter stakes in Khanna Industries, the litigation becomes irreversibly complex. Protecting the property from alienation is vital as held in Mandali Rangana versus T. Ramachandra. Third, irreparable injury. If these complex corporate assets...
Don't read the matter, argue the matter properly. Address the judge.
Yes, sorry, Your
Address
Honor.
the dais.
Apologies, Your Honor. Third, irreparable injury. It is, if complex assets are liquidated, the plaintiffs will be left with nothing but a paper decree. If the respondents flee, then getting justice will be out of the jurisdiction. If it may please this honorable court, the co-counsel will move to the next issue.
You are asking for interim relief injunction during the pendency?
Yes, Your Honor.
Where is the apprehension that they will alienate, they will sell the property, they will spend the money?
Your Honor, it
Have
is
you
one.
pleaded anywhere that there is an apprehension? Because that is the basic thing.
Your Honor, it is one of the assumptions that the plaintiffs are trying to make.
How?
It is it is one of the possibilities that could happen because
Have you pleaded anywhere?
I'm sorry.
What apprehension is having? If you are asking for the interim relief,
Yes,
what is the urgency of the matter?
Your Honor, if the properties are alienated, then it will be complex to recover them back. That's why.
You are asking for injunction, no, against them.
Yes, Your Honor.
Right.
So,
So there must be a apprehension.
Property is safe. There is no possibility of its disposal. Then why injunction should be granted?
because it is fulfilling the essentials of triple test, that is, it is
That's
a-
what we are asking.
So, apologies, Your Honor. It is fulfilling the essentials of triple test, that is, it is a prima facie case, there is a balance of convenience and
This
it
is not balance of convenience.
Your Honor, there is,
Explain how it is.
Your Honor, there is greater harm. There is greater harm done to the plaintiffs by rejecting it, by rejecting the interim injunction, than the harm done to the respondents
Demonstrate
by
how.
granting it. I'm sorry, Your Honor.
Demonstrate how.
Demonstrate how.
Your Honor, if the interim injunction is not released and the property is alienated, then the
Just now you agreed the property is in the safe hands.
Your Honor, the property is in the name of the respondents.
So prima facie, they are the owners of the property.
Yes, Your Honor.
You are asking injunction
Yes, Your
against
Honor.
them.
To prevent alienation
Yes,
of
then
that
where is
property.
the apprehension?
If you are asking for the injunction, there should be apprehension.
The counsel pleads ignorance, Your Honor.
Take. Carry on.
The counsel requests to move to the prayer. Wherefore, in the light of issues raised, arguments advanced and authorities cited, may this honorable court be pleased to declare that execution of the purported will remains unproven against Shruti Malhotra's incomplete testimony, direct initiation of complaint against section 340 of the CRPC, dismiss the demand of sealed cover documents and non-disclosure agreements, accept the request for injunctions, accept Kajal Khanna as the next friend of the minor plaintiffs without any additional court appointment, accept the claim of intestacy, accept the grant of accounts and direct transfer of assets to the plaintiff, accept the compensatory relief and criminal proceedings, or pass any order as it may fit in the interest of justice, equity and good conscience.
Thank you.
Counsel seeks permission to proceed with facts.
No, you can directly come to issues.
Issues? Okay. So my first issue is, I appeared behalf of the defendant, Ms. Prisha
To be
Segal.
little loud, I'm unable to hear you properly.
I appear behalf of the defendant, Prisha Segal. The issue is valid execution and a proof of a will. The defendant humbly submits that the purported will has been valid executed in accordance with the section 63, which is execution of unprivileged will of Indian Succession Act, and stands duly proved under section 68 to 71 of Indian Evidence Act. The will bears the testator's signature, is attested by two competent witnesses, one of the whom has examined the defendant and thus discharged the initial burden of proof. The defendant complies with the section 63 of Indian Succession Act, testator's signature. The document was signed in the presence of two attesting witnesses, Shruti Malhotra and Amit Mehta, affirming the execution. In her affidavit, the attesting witness Shruti Malhotra confirmed she was present at the residence of Mr. Khanna. Proof under section 68 to 71 Indian Evidence Act. The defendant asserts that the execution can be proven even if the witness recollects as per not perfect, as per the establishing the legal principle, fulfillment of section 68. The defendant has produced at least one attesting witness, Shruti Malhotra, who was affirmed the execution of the will. Section 63C, the will shall be attested by two or more witnesses concerned, while Malhotra states cannot confirm if both witnesses signed in the presence. Due of leaving shortly before the completion, this does not invalidate the will under section 71. Of the attesting witness denies or does not recollect the execution, its execution. Okay, sorry, ma'am. So she left the before the signing will. My point is the will is not validated just because the witness cannot remember every detail of the will, while the section 68 requires at least one witness to be called. Section 71 says that proof when attesting witness denies the execution. In the light of settled legal possession, the purported will dated has validate execution in accordance Section 63 of the Indian Succession Act and duly provided under Section 68 and 71 of Indian
So
Evidence
according
Act.
to you, will is valid.
Will is valid, ma'am.
It is registered.
No, ma'am.
It is
There
not
is
registered.
there is no requirement of registration of
Are
will.
you sure? Where is the provision?
The transfer of property, the value of the property is not more than 100 rupees. In
Yeah.
the provisions of transfer of property act, it requires registration.
Sorry, Your Honor, I am not aware of this actually.
You know whether that will be disclosed that it has been executed in presence of witnesses,
There was one witness.
that thing is different. But whether will it show that it was executed in presence of witnesses,
Is will it having this type of statement that it is presented, it is executed in the present of that witness,
Yes,
and it
sir.
is at,
Yes, ma'am. There
It
was
is-
a one person, Mr. Amit Mehta. He was present at that time.
that
you're not
witness
getting
says-
question. He
Sorry, Your
himself is
Ladyship.
a witness.
Sorry, I didn't understand the question, Your Ladyship.
Because the bill is acted upon accordingly whatever was written in the bill was executed or acted upon. Okay.
ठीक है, continue.
Council seeks permission to start with second point. Second point is alienation of forgery, fraud, and criminal liability. The defendant submits that
A little loud. Be close to the mic, yeah.
sorry. The issue says the burden of proof lies on the person alleging forgery. In defendants submit that the forgery, fabrication, fraud, and undue influence lived against the purported will, wholly misconvinced, unsustainable, and based on mere suspicious. It is sealed provision of the law at once proponent proves due execution and attestation of the will in accordance with a statutory requirement. The burden squarely shifts upon the person alleging forgery or undue influence. Establish the same by clear. In Venkatana Iyer versus Tindanjamma, the Honorable Supreme Court authoritatively held that the once propounded proves execution and attestation of will accordance with the law and the initial burden stands discharged, and the onus after that shifts the person alleging fraud, undue influence or forgery. In given settled legal possession, the absence
Don't
of
read. Approach to the bench.
sorry, my ladyship. In under section 467, forgery of a valuable security will is given in this section. It is respectfully submitted that the plaintiff have failed to prove the forgery and the undue influence. They are saying that we have done the undue influence or the forgery in this case, but this is not right. I have made sorry.
you are reading the notes which are with you.
So, sorry, my lord.
You are not arguing. Your own explanation
Do
is
you have
required.
any say about the forgery and this?
would like to shift the next issue.
You deal with your issues, no?
He'll deal
Let
with
her deal with her issues.
So, my ladyship, the third point is, he is going to explain the third point. From third point to 6, he is going to explain that.
From issue number 3 to 6, you are going to explain.
Council seek permission, proceed with issue number 3. Before the going of issue number 3, my lordship, validity is validly executed. I am, according to section 63 of the Succession Act, when the creating of the building, at least 2 witnesses are necessary, and when the proving the execution of validity, according to 68 of the Indian Succession Act, at least 1 witness is necessary. In present case, sir, what happened? One of the witnesses, that is Shruta Malhotra, denied the signature in presence of testator. That's one of the case law I am peruse, lordship. When 1 witnesses are denied or not said, not remind the presence of the witnesses, that is will deeds does not valid, invalid. So that was one of the case laws, lordship.
What is it?
Kindly peruse, lordship.
What is that case law?
Lordship, I given the case laws. In para number 7, lordship, ARI 1981, in case laws said that it is true that even evidence is such considered testator in presence of testator, mere fact of the witness does not specially state that they attested witnesses in the presence of testator may not invalidate the document itself. It is showed, its case law shows that one of the person denied in presence of signature when creating the will. That is when evidence come before the court, and Shruti Malhotra is denied.
Why the expert opinion is denied then?
Expert opinion is not necessary, lordship, because of clearly showed that she is denied the signature. And another one of the witnesses that is also present, Amit Mehta. Amit Mehta not come in the case cross examination. So when we witnessing the second witness, they will Amit Mehta said that this eye presence of the signature made in before the testator. So expert is not.
Deal with your issues.
Yes, lordship. Issue number 4 is that, issue number 3 is that seal the cover and confidentially and NDA, that is non-disclosure of procedure. Lordship, I have made before the application honorable court proceeding the will deed before the sealed cover that the application allowed and framed these issues. Lordship, my humble submission is that the court has inherent jurisdiction and settled principle of civil procedure when adapted to prevent the prejudice, protect privacy, ensure the fair trial, and media sensitivity. In the lordship, in the case publicity, use publicity in the case. That's why I made the application for the sealed cover and sensitive document of the will. So one of the case law for this issue, sir, Naresh Mirajkar versus State of Maharashtra. In the case law held at the Supreme Court, open justice subject to exception, and the court has lawfully restricted public access or disclosure where required in the interest of justice, fairness of the trial, and administrative of justice. So it is clear show that it does not violate the principle of open justice, lordship.
How it is you apply this principle in your case?
Lordship,
Then explain.
I made application for the honorable court to keep confidentiality and sensitive document, and court allowed my application. Court allowed application because lordship prevent the prejudice and protect privacy, ensure fair trial, and media sensitivity. Lordship, my case is very publicity. I am Sanju Khanna is very famous industrialist. That's why my case publicity. That's why I made an application for keep confidentiality of will. And sir, lordship, it's relevant case law, sir. The Supreme Court held that open justice is subject to exception and court may lawfully restrict the public access. So in case, sir, made public access, so for the restriction of public access or disclosure of where required in the interest of justice and fair trial and administrative justice. Case is relevant for this third issue.
You see, this Shruti Malhotra
Huh.
stated that I have not seen other witness while signing the will deed. Are you clear? And second is that this testator Sanjeev Khanna
Yes, my lord. Sir.
do not state in will deed that I have executed this will deed in presence of witnesses. When these are the facts,
Yes, my
then
lord.
how your will can be relied? Two things are appearing here.
Yes, lordship.
What are required? The will must be executed at least in presence
least
of
two
two
wit-
witnesses.
Yes,
Here, one of the witness which has been examined
yes, lordship.
says that I have not seen the another witness
Yes, lordship.
signing the will deed.
Yes, lordship.
One thing over.
Yes, lordship.
Second is that
Ah.
this Sanjeev Khanna
Yes.
in his will deed not stated that I have executed this will in presence of witnesses. Then how the essential ingredients has been proved?
Lordship, I want refer to one case laws.
No use of case law when necessary requirements are not proved. Then how case law will be?
Lordship, Shruti Malhotra is lack of memories and denies the execution signature in mid. That lordship, one of the case law Janki Bohor versus Narayan Kadam. In this case law held that while the execution section 68 required at least one witness to be called. If witness failed to prove execution, lack of memories.
About in the presence of Mr. Khanna was alive, that time he did his will.
Yes,
Right?
lordship.
So the concern is when he make that will, that time that will was executed in the presence of any witness, and that type of statement is mentioned in that will or not.
Not, madam. Not.
Then that is a question.
Your will is
Then
lawful.
your will is not valid.
Lordship, one of the problem is that she only Shruti Malhotra only one witness is still.
That question comes later. Comes to the primary things.
Lordship not aware of this issue.
ठीक. Proceed.
Lordship, proceed with issue number 4. That is issue number 4 is that interim relief and preserving the asset. My humble submission is that plaintiff is not entitled to interim relief because of lordship injunction under order 39 rule 1 and 2 CPC required 3 essential elements, that is prima facie case, balance of convenience and irreparable loss. That is in present case lordship plaintiff challenge the rest or mere allegation forgery and suspicious without any strong prima facie proof. That is not entered, this case not prima facie case. Second is that balance of convenience lies in my favor of, that is defendant. House lordship granting freezing order appointing the resource without grave irreparable distribution among the my business and investment and contractual obligation forming the estate, and no any irreparable clause to plaintiff because of lordship. No any solid proof of the defendant to selling or transfer or aside the asset now, saying that some accounts were wiped out. There is no any apprehension of for granting injunction for the plaintiff. It is a humble submission that plaintiff not come with clean hand. That is not entitled to interim relief. That is injunction. Lordship, one of the case law in for injunction granting injunction. I refer to my page number 60, 4.5. Dalpat Kumar was said, Parla Singh. In this case, law held that court the granting injunction cannot be granted on basis of only sympathy and unsustainable allegation. Only made allegation is will is not valid, not valid, not valid. That is my humble submission that plaintiff not on only on basis of only on basis of not made entitled injunction for the allegation. It is my humble submission. Lordship, counsel seek proceed with fifth issue.
Is time permitting? Time over? ठीक है.
Lordship, fifth issue is that my humble submission is that minor plaintiff by their mother Kajal, next friend, either not automatically or unconditionally under order 13(2) of the CPC, while the natural guardian merely act as a next friend without formal requirement of court. Such entitled in present case, Kajal Khanna personally and litigate interests are clearly intervened with, and potential adverse treat for order 32 clause 9 said that disqualification of next friend because Kajal are adversely affected the
Is it proved that she is having this type of interest?
yes, my lordship, because of challenging the will deed on the basis of the huge amount, that is 30,000 crore rupees. She also,
She is looking for the better interest of the child, and that is a basic right of that mother.
lordship, only, you challenge only the movable property, that is will deed, not claim the my industry, Sanjeev Khanna industry, that is amount. That is also adverse benefit, take the benefit, that is as a next friend. That is one of the adverse interest.
But Mr. Sanjeev also wants to protect the interest of the child,
Yes, already made out the trust.
right?
Yes.
He already made the trust.
Yes.
And through that trust, he wants to protect the interest of the child.
Yes, lordship.
So his interest is only that mother is protecting. So what's wrong in that?
Lordship, in present case that Kajal Khanna personal and litigation interests are clear.
That's what we are asking. What that interest is? You are saying that alleged interest. What interest is? What that?
She taking the benefit amount of the 30 crores.
Is it proved?
Yes, lordship, in facts of in vouchers case. Lordship,
Facts cannot be referred as a matter of evidence.
lordship, in the case in present competition in held that account statement in on record, that is opening balance of the
It is already public.
yes, my lordship. My lordship, for this question, my humble submit that suppose she is acting next friend, she claim for the only will of the immovable property. She cannot take the
She is just working for the best interest of the child.
yes, my lordship, but also sir, adverse interest take benefit of that estate.
Just tell me the answer for the adverse benefit you are talking. You are arguing, you are quoting lot of matter for adverse benefit. What is adverse benefit?
She,
And if that adverse benefit is there, whether that adverse benefit is proved?
lordship, not proved, but I am saying that she is taking the advantage of this estate, that is amount, huge amount. So lordship, she act as a next friend, but she cannot claim assets. Lordship, with the permission, prayer.
We already know the prayer.
Yes,
Much obliged, lordship.
okay.
No rebuttals now. No rebuttals. Yeah.
Sufficient time given.
Yes, thank you. हाँ, सर आ गए. अच्छा, ठीक है. ते लवकर कन्क्लूड करा. ते आले. नाही, येतात आहे ते 15, 7:30 ला येतात.
येऊ द्या ना त्यांना, आपण दिवसभर बसलो ते बसतील कोर्टाबरोबर.
Yes, court officer, start the proceedings.
Yes. Counsel seeks permission to directly proceed with the arguments advanced. So, issue 1 has to do with whether the purported will dated 21st of March has been validly executed in compliance with section 63 of the Indiana Succession Act, and whether its execution can be proved under section 68 to 71 of the Indiana Evidence Act. So, firstly, it is humbly submitted before this court that in examining the validity of a will, it is to be proved in accordance with section 63 of Indian Succession Act and 68 to 71 of Indiana Evidence Act, and then in the present case, there are certain principles that have been provided for due execution of will, as have been outlined in the case of Bhagyavati versus general public. So in this case, there are a list of circumstances provided. I'll only be the counsel will be highlighting the ones that are pertinent to the case. So the testator should have signed or affixed his mark on the will in the presence of the two witnesses who are required to see the testator signing or affixing his.
Kindly approach the bench. Yes.
Yes, Your Lordship. So, section 63, subclause C states that the testator should have signed or affixed the mark, and that the will in the presence of the two witnesses who are required to see the testator signing the will. So, we can see that the two if Your Lordships would refer to the affidavit that has been provided, Annexure B, it is clearly seen that it is only the it is on Ms. Shruti Suri Malhotra, that is one of the that is one of the attesting witnesses, has provided a very shaky and demonstrably shaky testimony, because on the one hand they have stated that okay, the other attesting witness was present, that they were present at the place of signing, but then they have themselves not certified their own signature. They have not mentioned anywhere that they have signed in the case. They have signed after they have attested to the execution of the testator. It is also seen that the attesting witness number 1 has left after the signature by the testator due to a business meeting. So they also cannot certify whether the other attesting witness, which is Mr. Amit Mehta, has attested to the will. So there is only so we cannot guarantee that there is attestation by both the witnesses. What we can say is that there is attestation by one witness at best. So regarding the same, there is a provision where it is provided. Just not sure. Last one. So the statements that have been given by Ms. Shruti Suri Malhotra are only descriptive. So she has stated that she had seen the attestation of the document that was called the last will of the testator. But then this is only descriptive. So all that we understand from a document titled the last will is that there was a document as such. What we do not understand.
Go to the next issue.
Yes, Your Lordship. Issue 2 is regarding the allegations of forgery and fabrication. So under issue 2, it is pleaded that the will was a typed will. It was not a handwritten will, because nowhere has it been provided that the will was handwritten. So when it comes to typed or computer generated wills, it can be seen that there are many individuals who will go for a typed will. But then the fact of the matter is that we have to prove that when it comes to cases involving forgery and fabrication in general,
the signature of the Mr. Khanna is authenticated?
the signature of Mr. Khanna cannot be authenticated in the present case.
The will was signed by him?
Yes, the will has been signed. So when it comes to typed wills, the will is first drafted by a typist, a scribe, and then it has to be signed by Mr. Khanna, the executor, the testator. But in the
So that was the will was executed in the presence of the witness?
the will was not executed in the presence of the witness, because we can see that the attesting witness 1 has herself not provided any positive statement which signifies that it was attested, it was executed in her presence. Further, we know that the testimony, the sole testimony, testimony that we have before us is not valid to the extent that attesting witness 2, there is no information about whether it was attested by attesting witness 2. So the execution has not occurred, the ingredients of execution have not been satisfied.
Whether
Further,
the will was registered.
in the present case, it is stated that the will was not registered because there is no stamp of stamp of the notary, and then and the presence of the
Where the
sub-registrar is
provision
also
for
not
the
provided.
Registration of will is given.
Pardon?
Where the procedure for the registration of the will is given.
Council seeks, council please ignorance.
Whether will is required to be registered.
Will is not required to be registered, Your Lordship.
Are you sure?
As per what provision?
So registration by
For
itself.
valid will deed, which provision you are going to refer under Succession Act? Whether that section requires that will must be registered?
There is no requirement that says will must be registered. Your Lordship, further, so the fact that it is a typed will is of importance in this case because unlike a handwritten will, in a typed will there is no indica of authorship. No one can understand like who is the person who has made the will. So in such a case, it would be important to understand who is the typist, who is the scribe, or who has drafted said will. So in the entire circumstances that we have been provided with, what we understand is that there is no typist, there is no person who has drafted the will, there is no draft of the will. What we simply see is that a will has been placed before us. That is all. And
You
it further.
You claim that will is forged document. Got it? You claim that will is forged document. That
Your
has
Lordship,
been
the
prepared.
council is. Council,
Let me hear
Yes, Your
your
Lordship.
question. Who forged this document according to you?
it is Prisha Khanna in coordination with the executrix, that is testator number 1, Shruti Suri Malhotra.
When this Prisha Khanna herself disclosed before in presence of Kajol that Sanjeev not left any will.
So,
She fairly stated no will is kept there. And subsequently it revealed that will is there.
so that is
Then
stated.
how this Prisha can be blamed for preparing this document? How it can be imagined?
Your Lordship, it can be seen as an attempt to misguide the court. The way Prisha has tried to first show that there is no will made, and later it can also be seen that no copy of the will was furnished to Samira and Kiran Khanna. So later we saw that there was a letter that was drafted by Kajol Khanna on behalf of Kiran Khanna, where it was to Shruti Suri Malhotra asking them that why has the copy of will not been furnished to us. So we can see that there is some conspiracy occurring between them. Also further, Your Lordship,
Deal with different issue now. We got this issue.
Council seeks to proceed with issue number 5. It is submitted that Kajol Khanna is competent to act as a next friend of the minor appellant without any prior court appointment in this case. Because Kajol Khanna has not sought any personal proprietary relief. So the reliefs that are being claimed are very protective in nature. It is only for the protection of minors' inheritance rights and the preservation of the estate. So the rights and restrictions of natural guardian here in this case, which is Kajol Khanna, do not conflict with the procedure for filing the suit by a next friend. Further, it is submitted that her conduct here has demonstrated bona fides because she is only filing the said suit and arguing there on behalf of Samira Khanna and Kiran Khanna. Further, there have been no circumstances which have arisen which are warranting the displacement of the next friend, because no party has sought the appointment of a guardian ad litem. So so we have to understand that when it comes to this court procedure, it is not automatic that a guardian ad litem be appointed. It is only it is a court intervention that acts as a corrective measure. So it only arises upon proof of conflict or dereliction of some duty. finally, it is submitted that in the case of Nagaya versus Chaudhama,
You deal with your issues,
yes, Your Lordship.
then co-counsel will proceed.
Information.
Right.
Dealing with which issues?
Issue 3, 4, and subsequently 6, Your Lordships. Your Lordships, as far as, is the council audible? Yes. As far as issue 6 is concerned, firstly, it is important to understand that there is no dispute to the fact that the sealed cover mechanism is a valid mechanism or is a valid procedure under law. Sure it is, but Your Lordships, it is important to question under which conditions this sealed cover mechanism is being applied. And that is why 3 important contexts are to be set. Number 1, that the testamentary validity of the will is under dispute, which is already established. Number 2, that the corporate control is arising out of MCA beneficial ownership forms, which under the Companies Act are in the form of 2 forms, BEN 1 and BEN 2. Your Lordships, in light of these contexts, it is important to understand how the right to fair hearing on behalf of the plaintiffs is being violated. Your Lordships, if my Lords may refer to paragraph 39 of the Madhyamam Broadcasting Judgment, it is very well established that it says there are 2 primary principles of natural justice, right to fair hearing, audi alteram param, and nemo jude in causa sua, which is very well established. But it is important to define what right to fair hearing means in order to connect to how this right to fair hearing is being violated. So, Your Lordships, therefore, right to fair hearing includes the right of a party to be informed of and to meaningfully respond to the material relied upon against it, with special emphasis on the party's ability to meaningfully respond to the material as well. Therefore, if you look at the Madhyamam Broadcasting case, the fact that we, the council, have access to the confidential documents under the sealed cover is not enough simply because we cannot discuss those details with our clients because it says for counsel and for legal use only. Again, there is no case or there is no navigation through which we can refer to expert opinions or test the validity of whatever material is being submitted. And that is why there is a violation of a right to fair hearing in accordance with the principle set in the Madhyamam Broadcasting case. If you look at Madhyamam Broadcasting case further, Your Lordships, in accordance to para 88, it sets 3 standards that are supposed to be validated before setting out or before putting in place the sealed cover mechanism: legitimate goal, rational connection, and balancing stage. If my Lords could move to para 89 of the judgment, the legitimate goal aim must be of sufficient importance to override fundamental rights, and the Madhyamam case very explicitly says that states are required to prove that confidentiality and national security, which were legitimate aims in those cases, are legitimate aims. Further, para 94, Your Lordship, says that states must prove the facts which indicate that the information sought must be kept secret, as their divulgence would affect the respective aim. If we apply what these 2 paragraphs say, firstly, the identified aim here is privacy and confidentiality. That is humbly submitted. Secondly, the question that is posed before the bench is, how can private confidentiality constitute an aim of sufficient importance to override our right to a fair hearing, which includes all of the other factors which we have mentioned earlier? So the question that really we must ask ourselves is, if confidentiality is confidentiality that we are seeking, is that really being joined in nexus with here? Because the party, again, para 89 very clearly says that party that is invoking confidentiality must prove the factual basis that indicates that disclosure would harm the asserted aim. There is no specific pleading from the defendant side which says that a harm would be arised if there is disclosure. Therefore, the legitimate aim case is completely disproved. As far as, even if you look at the inapplicability, there were certain justifications that were made in the Madhyamam Broadcasting case, wherein certain limited procedural restrictions were
Come
allowed.
to all this application in the present case, whatever the case you have.
Yes, Your Lordships.
Don't explain the case laws.
Yes, Your Lordships. So, Your Lordships, there, the legitimate aims as mentioned were national security and intelligence-based confidentiality. Here, again, those aims are private testamentary and succession dispute. This is a case, the subject matter of which revolves around private testamentary and succession. So the question is, shouldn't the threshold for a private and testamentary and a succession-based dispute be much higher than for a case which was revolving around national security? So the submission is that the threshold which the Madhyamam Broadcasting has set was for facts that revolved around national security, and the threshold in this case to identify or to establish a legitimate aim is much more higher, which the defendants have failed to do. Further, if you look at rational connection, it looks at whether the means would increase the likelihood of protecting the interests. Sealing the access from the petitioners does nothing like that. All it is doing is excluding our litigating party from access to that evidence. And therefore, the third idea of least restrictive means is also disproved because there are multiple lesser restrictive means that are available. To name three, there is reduction of sensitive portions which can be done. In-camera proceedings as an option is available, and limited confidentiality undertaking is also available. So we don't understand why there is why the complete subject matter of the entire asset list is being looked after here. Your Lordships, moving on to issue 4, just one submission under issue 4, Your Lordships. It is well established that there are again 3 cumulative requirements under the Neon Laboratory case. That a prima facie case has to exist, there has to be violence of convenience, and irreparable loss or injury has to exist. As regards to prima facie case is concerned, the Dalpat Kumar judgment in para 5 very well says that prima facie case must not be confused with prima facie title, which essentially means that at the interim stage, there are only 2 rules or 2 classes that we have to tick. The first one being that the claim is not frivolous, and the second that facts disclose a legally recognizable right, both of which have been corrected and both of which have been validated in this case. If you look at the second criteria, which is after irreparable injury, Your Lordships, there is a Joy Auto Works judgment, which para 43 reads that unlike immovable property, financial assets are inherently fluid. So this case cannot be treated with other cases which are of immovable property because traceability of these assets are more fluid in nature, and traceability is very complex and almost impossible in nature. And that is why the irreparable injury aspect of this stage comes into picture. Therefore, Your Lordships, it is humbly submitted that with regards to the 3 cases, the arguments made by the defendants with regards to how these 3 cases must be satisfied has failed. Your Lordships, just one last submission with regards to appointment of receiver, because appointment of receiver is something that the petitioner, the plaintiffs have been asking for, which has been looked after into the T. Krishnaswamy judgment. Your Lordships, there are 5 criteria in order to establish whether appointment of receiver is required or not. First is that no adequate alternative exists, which is true. The defendants might argue that under 41H of the Specific Relief Act, it says that if there are more efficacious reliefs available, then injunction cannot be granted. And that same logic can also be applied to appointments or appointers as well. The only problem with that argument is that when we look at a probate as an option to look at this case, it will only determine the validity of the case and it will grant representation. A probate does not have the power to freeze assets, prevent dissipation, etc., etc. That is why this is the only adequate alternative remedy that exists. Second, excellent chance of success. Your Lordships, given that this is a will, the burden of proof shifts completely. So presumption of validity shifts completely, and that is why, since we have already established a prima facie case in issue 4 with regards to injunctions, that same logic also applies to the presumption of success in this standard. Thirdly, imminent risk. When we have established irreparable injury, and when we have established that those assets once transferred are extremely complex to trace, and even though money in forms of damages can come back, but corporate control over those family assets can never be returned in time.
Got the point. Come to the prayer clause.
Yes,
Time on.
the council
Shortly,
would.
your prayer clause
Yes,
clause
Your
is very
Lordships.
detailed. Just short.
The council,
Crux of it.
the co-council would read the prayer, Your Lordships.
Don't read it.
Yes, okay.
Just tell what you're asking for.
Yes, Your Lordships. Firstly, is it fine if you don't read the entire prayer and
Just, let us know the crux.
okay. First, to declare that the perpetrated will of 21st March has been executed validly by late Mr. Sajeev Khanna. It is invalidly, my apologies. It is illegal, invalid and unenforceable, and therefore void ab initio. Yes, that is the first prayer. Second, that declare that upon intestacy, the rules that have been applied under section 8, 9, 10 of the Hindu Succession Act for the rules of intestacy will be applied, therefore giving 20% shares to all the 5 stakeholders available in the estate. Thirdly, to declare that, again, Mr. Khanna has died intestacy, to direct a comprehensive forensic examination of the perpetrated will, along with more access to the assets document, because only counsel access is not enough in order to discuss with our clients with regards to what exactly has to be the next step of procedure. And lastly, to grant interim injunctions restraining the respondent from alienating, encumbering, transferring, or creating any third-party rights which may further cause problems. Thank you.
Council seek permission collectively to address the bench as Lordship. If Lordships are familiar about facts, then Council seek permission to move towards the issue. Much obliged. Your Lordship, the issue number 1 is concerned with whether the purported will 21st March 2025 is valid under Section 63 of Indian Succession Act and Section 68 to 71 of Indian Evidence Act. May it please your Lordship, under Section 63, under Section 63, lays down the mandatory conditions for the execution. In the present case, the testator signed the will and 2 attesting witnesses, Ms. Shruti Suri Malhotra and Mr. Amit Mehta was signed. This proved in Annexure A given by the purported will. Please refer Annexure A. This compliance with the statutory mandate is further forfeited by Supreme Court clearly mentioned that in N. Kamalam Ayyaswamy, animus attestandi, intention to attest. And Section 68 of Indian Evidence Act clearly states that only 1 attesting witness is required, and is held in Supreme Court in Janki Narayan Boyer versus Narayan Namdev Kadam that only 1 witnessing signature is examined and it not invalidate a will. Suspicion must arise from the transaction itself, not from the disinheritance, the natural heirs. Here, the will explicit that the minors Samira and Kiran were already provided.
If the will was valid, when the plaintiff asked for the will, why the will was not provided that time? Why the copy of the will was not provided that time?
Because of secrecy and to prevent from media trial. If
they are also successor.
but
If you are not considering the first wife, but the minor children are the successor.
minor
So they have a right.
minor children are already provided in 2018's trust, and Kajal Khanna
I'm talking about the copy.
in Annexure A purported will. Here clearly mentioned that the minors are provided family trust from 2018. Annexure A of purported will.
I'm talking about the copy of the will,
Copy.
because it was denied to the parties.
Yes, yes, we go through. We
That
have
is
got
there.
it,
I'm
we
just
go through.
asking why it was denied. First, the plaintiff asked for the copy. You denied, and then later stages you provided the copy.
For protection from media trials. And in annual general meeting, Prisha clearly disclosed the will.
That's the reason I'm asking why the Prisha has not provided the will earlier when the copy was asked by the plaintiff.
Pardon your lordship.
Why the copy of the will is not provided when asked by the plaintiff?
Confidentiality, because of
What
confidentiality.
confidentiality? What is confidentiality? If their rights are also included, they are also part of that will, then why the copy was not provided in the first attempt?
Because Kajal Khanna is separated.
That's fine, but the two successor, that is a minor children, for whom the representation is done by the natural guardian, that is a mother. Through the Kajal Khanna, and Kajal Khanna only asked. Then why this right was not, like why the will was not provided in the first attempt? Which type of confidentiality?
To prevent from media trial and other.
How, like if you are giving that copy to the parties, then party will directly start a media trial.
No, but it is risk for disclosing of events.
Sorry? It is not the denial of rights, or it is not the denial of the interest that the parties vested in the parties.
But it is disclosed in an annual general meeting also. That's why, when everyone is present.
Go to the next issue.
Whether the plaintiff have discharged or can discharge the onus of proving that the purported will is fabricated or caused by fraud, undue influence, the Act attract criminal liability under Indian Penal Code of 467, and whether a civil court should be direct or concurrent criminal proceeding. May it please your lordship. The offence of forgery under section 464 and 463 of IPC applies only the making of false document. Here, plaintiff does not submit any document that prove that the will is invalid and false. Mere allegations of fraud or undue influence required a clear and strong evidences. In H. Venkatacharya Younger versus B.N. Thimaji and Shashi Kumar Banerjee versus Subodh Kumar Banerjee, the Supreme Court said that suspicious is not invalidate a will. It requires evidence. Burden of proofs lie on the challenger to make the allegations. Even if a beneficiary is only one, that the time of and it is present at the time of execution is not create a suspicious circumstances. Even if a will is disputed, later found invalid, does not automatically become a false document under criminal law. If petition, if plaintiff require if plaintiff trying to say that it is a criminal case, then plaintiff must move towards the criminal court. Under Birla Lodha, it is clearly stated that the court probate is to fulfill the genuineness of the will, not the criminal liabilities. Therefore, the plaintiff have failed to prove forgery, fraud, undue influence. No requirement of section 467 of IPC is satisfied. Their attempt to give a criminal
was not registered.
No.
The will was executed in the presence of the witness.
Yes.
In the when Mr. Khanna was alive, that time he mentioned that statement in the will.
Yes.
That this is it mentioned?
Yes.
No, go through
Where
the
it
will.
is mentioned?
He has not stated that I have executed this will in presence of witnesses. No statement is there to that effect.
Sorry, pardon. I am unable to hear. Sir.
Khanna do not claim that will has been executed in presence of two
witness.
witnesses.
Yes, Ms. Shruti Suri Malhotra and Mr. Amit Mehta.
That appears.
When he did that will, that time, have he made any statement in that will itself? We are not talking about that execution. We are talking about the statement in the will. Whether this type of statement is mentioned in the will.
Which type of
That
statement?
Mr. Khanna has executed this will in the presence of the witness. Whether this statement is mentioned in the will.
But affidavit of Shruti Suri Malhotra clearly state that she was present at that time.
When the person is not there, I can say anything.
But when affidavit is provided, then
I can say anything. So Shruti can say anything. Maybe the Shruti's interest lies.
no, in will there is no mention that Shruti's interest is lies. Only
The Prisha may provide the interest latter stage.
Yes, another question. In this will, it is stated that provision by way of creating family trust has been made in favor of two children.
yes.
Whereas no provision is made in respect of old mother. What about this?
If old mother is in undue influence of Kajal Khanna, then she was claimed for it.
Undue influence?
Then
Whose
Shruti
undue
can also
influence?
sign the document under the undue influence of the Prisha.
But she mentioned that she left shortly. So how can we state that undue influence?
Okay, you proceed. You deal with your issues.
Issue number 3.
You done or you
Whether anything remains.
No, my co-counsel will submit further issues.
Yes.
May it please your lordship, co-counsel seek permission to refer issue number 4. The fourth issue before this honorable court is whether the plaintiff are entitled to immediate interim reliefs to prevent dissipation of alleged assets tests to grant injunction. Your lordship, the above reliefs are extraordinary equitable remedies. They are not granted as a matter of a course upon filing a suit by required strict satisfaction of the triple test under Order 39 of CPC that required a prima facie case, balance of convenience and irreparable injury. The plaintiff have failed to establish a prima facie case. A mere challenges to a will does not automatically justify interference with its administration. The defendant is in a lawful control of the state until credible evidence of fraud, invalidity or misconduct is shown. That the state must be allowed to operate in its ordinary course. In the case of Dalpat Kumar versus Prahlad Singh, it has been held that a prima facie case requires a substantial question of law supported by a credible material, not mere allegations. There is no irreparable injury demonstrated by the plaintiff.
kindly approach the bench.
Okay, much obliged, Your Lordship. The assets are identifiable that under a lawful, it is under a lawful management. There is no evidence of concealment and destruction or diversion. Your Lordship, the appointment of a receiver is a drastic step or to reserve for cases where property is in imminent danger. Interim relief is meant to preserve the status quo, not grant a premature advantage. There is no urgency, no demonstrable risk, and no irreparable harm. The application must therefore be rejected. If Your Lordships are satisfied with this issue, may I continue? Next issue, much obliged. The next issue, issue number 5 before this honorable court is whether Kajal Khanna can act as a next friend, represent the minor's plaintiff without any additional court appointment, and what are the safeguards under Order 32 of CPC. Under Order 32, Rule 1 of CPC requires a minor to sue through a next friend, but the court retains a duly examine the suitability of the proposed representative. The Kajal Khanna is a former spouse of the testator and is personally involved in litigation concerning the state. The Latin maxim that nemo judex causa sua, that no one can be a judge in his own case. Your Lordship, the dispute concerns an estate valuated at approximately 30,000 crore, where litigation affects substantial proprietary rights of minors. Court applies stricter standard of vigilance to affect substantiality proprietary of minors. Court apply greater stakes require a greater judicial caution. Indian law consistency hold that the welfare and a legal protection of minor override all personal claims, including those of parents. The person seeking to represent minor must affirmatively demonstrate that they are free from conflicting interest and acting exclusively for the minor's welfare. Neutrality is not a presumed, it must be affirmatively established to the court's satisfaction. Where doubt exists, the court must adopt protective approach that prioritize the minor's legal scrutiny, legal security over parental preference. Your Lordship, therefore, even if the will is set aside, Your Lordship, the law governing minors is built on the principle that justice must not only be done but must be seen to be done free from parental conflicts. Therefore, her request to act as an ex-friend deserves to be rejected. If Your Lordships are well satisfied
Why
with
it is rejected?
Yes, Your Lordship.
Why it needs to be rejected? She
Because
is a
law-
natural
you-
guardian.
Yes, Your Lordship.
She is a natural guardian.
Yes, Your Lordship.
Which act is prohibiting her from becoming a the next friend?
Your Lordship, in the present case, in the present suit, she is both a claimant and a next friend.
So explain her adverse interest.
Yes, Your Lordship. In the present case, if the ill will is invalidated, then she will get a shares, and if she will, then her personal financial stake in the state can conflict the minor's interest.
How it can be affected?
That will be useful
She's
for
working
minor.
for the betterment of the child, and that's what the Mr. Khanna want.
Your Lordship, here the circumstances is that she is a
Whether the circumstantial evidence can be considered.
Your Lordship, but here the court will we are not denying that, but we just want a judicial scrutiny that if she if the
Have you written anything about the judicial scrutiny in your memorial?
yes, Your Lordship.
Where?
Judicial scrutiny.
Tell me. Where
Yes.
you have written about the judicial scrutiny?
It's my own statement, oral argument that
Your own interpretation.
we
no?
claim that, Your Lordship, we claim that the judicial scrutiny, we are
Is it mentioned in the memorial? Or
judicial scrutiny is
it is not mentioned.
Who prepared that memorial?
myself.
You yourself.
Yes, Your Lordship.
It is not mentioned in the memorial. Yes.
Yes, Your Lordship.
Last issue you have any?
Yes, Your Lordship.
Deal with the last issue.
Okay, issue number 6 before this honorable court is, what is the correct relief if the purported will is set aside, declaration on intestacy and distribution under the Hindu Succession Act, B, grant of accounts plus direction to transfer assets to the plaintiff, C, compensatory relief and criminal proceeding. Your Lordship, if will is set aside, then succession will govern under section 8 of Hindu Succession Act 1956. The state devolves upon all class 1 heirs equally. The plaintiffs are only some of the heirs and therefore can claim only the statutory share, not the entire state. Your Lordship, probate and succession jurisdiction does not extend to determining civil or awarding damages as held in the case of Anil Bihari Ghosh versus Latika Bala
What is the
Dasi.
difference between probate and will?
Yes, Your Lordship.
What is the difference between probate and will?
Oh, pardon, Your
What is
Lordship.
the meaning of probate?
Probate means kind of registration.
You are not aware.
Yes, Your Lordship.
Accept it. My
Pardon,
there is
Your Lordship.
confusion. Yes, proceed.
Much obliged. In the case of Anil Bihari Ghosh versus Latika Baladasi, the court only administers the estate. Mere invalidation of a will does not imply fraud or wrongdoing. Civil court exercising succession cannot direct a criminal prosecution. Civil and criminal proceedings operate in a separate sphere. As held in MS Sharif versus State of Madras, any alleged offense must be pursued independently before criminal court. Granting the entire state to plaintiff would unlawfully disinherit the class
Time
1
is over.
heir.
We got the points.
Yes.
Time is over. We got the points. Sir, any question?
Lastly, let me know if interim relief is granted in favor of plaintiff, what damage is going to cause to you, how
Yes,
you
sir.
are going to suffer.
Yes, Your Lordship, it will be effect to the minor son's welfare as well as the business and the tax and the salary of laborers, welfare of testator's minor child and all. If Your Lordships are satisfied, may I refer prayer clause?
We are aware about the fair clause.
Yes,
Much obliged, Your
yes,
Lordship.
time over.
No rebuttals.